Hey everybody, welcome to Active Self-Protection Extra today on John's Briefs with Terry Johnson, the most moral, upstanding attorney that I know. That's a pretty low bar, but you know.
It's not feeling well.
And I want to talk today about the difference between a trial and the appeal, and maybe we'll expand it either on this one or the next one into discussing from there about how case law affects you. Firearms Legal Protection just started a 100% free monthly newsletter to bring quality, accurate information about legal self-defense to good, sane, sober, moral, prudent people like you. Go sign up for free, no-hassle help for your self-defense at the link in the description, and thank them for sponsoring today's lesson. So, Terry, we have a trial that happens. Let's just say that you know, we didn't have an agreement, right? We didn't make a plea agreement, and we decided...
You're part of that 3% that go to trial.
Yeah, most of the times, if charges are brought, 97% of the time, it's going to go to a plea agreement. A plea agreement can be a very good thing for you as a self-defender because a district attorney might go, hey, I got to get something out of you. You're going to plead to disorderly conduct and keep your weapons and all that stuff.
Right.
And you go, yeah, I'll sign off on that. Have a nice day, and we leave that alone. But for the 3% that don't, we have a trial, and hopefully the trial goes correctly. We were upstanding moral people. We did the right thing. We get a not guilty verdict. Okay, but it doesn't always happen, right? Correct. If we get a not guilty verdict, we're done.
Game's over.
Game is over.
Put the win in the pocket, go home.
Prosecution can't retry on those charges because double jeopardy problems. Okay, but if the prosecution...
Sure you haven't been to law school?
I have not, and I will not.
Yeah, not yet.
Will not. And then the prosecution instead then gets a conviction, all right? But it's not game over yet. Correct,
because you get an automatic appeal in every state on a felony charge.
On felony charges?
Yes. Misdemeanors, I'm not sure.
Depends. Misdemeanors aren't as serious, right?
So, but for sure, in every state, you get an appeal. And the appeal is not what people think it is. The appeal is not, gee, the jury got it wrong, let's retry the case. The appeal is strictly looking at, was the law applied properly?
Let me clarify that. Let's make sure everybody understands that. We're not re-arguing the facts of the case. In Correct. The trial court, we're arguing the facts. And how did the facts fit the law?
Correct.
We're not arguing that in the appeals court.
No. Was the law applied, and was it applied properly?
Right. Now, not just the law as it was read to the jury in terms of what was there, but the actual law of how a trial is supposed to go as well.
Everything from the voir dire, were there any inappropriate questions asked?
Voir dire is choosing a jury.
There's the Babson arguments that could potentially come about. Now, those are things that, if you dismiss, let's say the prosecutor dismisses 3 black jurors in a row, then I've got it doesn't have to be 3, sometimes it could be 2, or just depending on how it happens. I will have to place something on the record that they are dismissing black jurors because, assuming I've got a black client, but they're dismissing black jurors to not make sure my client gets a fair chance. It's all these things from voir dire all the way to the very end with jury instructions and, Was the evidence that was allowed in correctly? Was discovery done right? Were the judge's rulings correct? Was the jury instructions read correctly? Specifically in self-defense cases, a lot of times, hopefully every time, the defense attorney is going to ask to have a self-defense instruction read to the jury. So, interesting, there was a recent trial where the judge gave 2 different self-defense instructions. One, this involved a baton. Okay. Now, one, the judge said, the prosecution argued it's a deadly weapon. Okay. The defense said it's not a deadly weapon under law. So the judge gave 2 different instructions. One with using it as a deadly weapon, and one as a non-use of a deadly weapon. And the jury came back hung. So we believe, that was simply based upon the instruction that the judge put out. So if that would have been a conviction, that obviously would have, moved forward. Because if you notice in a lot of jury trials, and a lot of you may say, well, why are they making why is the jury's in and then they're out, they're in and they're out? Because some of these motions are being made at this point. Right. And
what is the jury going to hear?
Yeah, well, it's not just what they need to hear, but these are arguments to be made for appellate level situations if in fact it gets to that point. So if you don't ask the question right then and do it right then, you forever lose that right.
So in the trial, we're arguing about the facts, and we're not arguing about the law, the application of the law, we're arguing about the facts.
Correct.
Here's what happened that day, here's my theory of why that happened that day, whether or not that was good, not good, whatever. When the appeal happens, were the rules applied correctly? Was the right evidence allowed? Now, an appeals court may say, no, the judge did this thing incorrectly. I think there's a big case, probably the most famous case right now with Derek Chauvin, right? And the George Floyd killings, which we could call right now a murder, right? So Derek Chauvin was convicted.
Correct.
But I'm gonna guarantee you that what happens was when Maxine Walters came into town and started telling the protesters, you get loud if you don't get a conviction. If I'm the attorney for Derek Chauvin, I'm filing an appeal saying that's prejudicial to the jury that pushed a verdict that they didn't want. Now, I don't know if Chauvin's attorney filed a motion there for a mistrial.
So here becomes the question. This is interesting. So does Maxine Waters, whether she's elected or not, have a First Amendment right to say what she wants to say?
That's as an elected official, right?
And I'm not agreeing with what you said. Let me make sure that's right. But I want you to really think about it from a lot of perspectives. Does the court have jurisdiction over her to stop her from doing that?
And then there's the question of, okay, wait a minute, would that unduly pressure a jurist to get a verdict to avoid a consequence on them?
So you'd have to bring all 14 in, and I say 14 because you have
12 and 2 alternates, yeah.
And, you'd have to say, one of them would have to say, after hearing what Maxine Waters said, I really thought I better convict this guy. That's what would have to happen in order for that to be overturned on that part.
So that's when, okay, so wait a minute, he didn't even consider it, and we didn't have that, so that wasn't a fair trial, now we need a new one. And so when an appeals court reverses a conviction, it's not just we're done, it's go do it again.
Go do it again, and most people don't want to do a second trial again.
Right. So a lot of times the prosecution at that point will go, yeah, we're not going to retry.
Well, not necessarily. It depends. So I've seen some jurisdictions do 2 or 3.
Wow.
Retrial depends on the charges and things along those lines. But it truly gets down to, at that point, it's a lot narrower. So you talked about case law in the opening. Now think about this. Case law actually comes from the appellate court and the Supreme Court.
Right.
So what that means is...
The Supreme Court is the appeals court to the appeals court.
Correct. And the United States Supreme Court can potentially be the appeals court to the state Supreme Court if there's a federal question involved. So, but the bigger part of all of this is, it's all over the place.
And I will say this, this was actually one of the things I learned that I really liked reading Ruth Bader Ginsburg's memoirs, which, okay, we can talk about that till the day is done. But she said, the Supreme Court is not final because they're right. They're right because they're final. So she goes, look, it's not that the Supreme Court never gets it wrong. We're just the last one that's going to come. You can't argue past us.
Right, and people accept that. There is no other avenue, and
we've argued it enough.
Right, and we've jumped through, and everybody narrows it down a little. But when you talk case law, that's where some of your jury instructions come back in, because those are the things that are really magnified when you get to the appeals court. Were they given the law properly to evaluate?
Yes. Were they said the right things? Were they given the right criteria?
Right.
Was the right evidence allowed?
Yes.
Was the jury allowed to come to a just verdict?
And here's the way this works. So they look at the judge. Did the judge make the right rulings along the way? If the judge didn't make some of the right rulings, the question becomes was it a trivial error where, well, yeah, he said him instead of her, it's no big deal, or, they allowed the defendant to come in jail garb, okay, which is prejudicial to the defendant,
right,
as in front of the jury. So when you see things like that, those are the kinds of things that they say, no, the judge made a mistake, it prejudiced the jury, so therefore, we're going to do this, we're going to move it forward. That's how that works on that end.
And so that appeals process, the ones that you will probably know about here in the self-defense world, right, in our world, DC versus Heller, a big one.
Yes.
McDonald versus Chicago is the
Yes.
follow-up to that. So in DC versus Heller, Dick Heller said, wait a minute, I want to have the right to own a firearm in the District of Columbia, and I'm denied that right.
Right.
And so the judge said, no, you are not denied that right. So then he appealed, and the appeals court said, no, you're not denied. Well, then finally the Supreme Court said, and Scalia wrote a beautiful opinion on this, that he said, the wording in the amendment is very clear. You have the right to keep and bear arms. Therefore, you have denied him the right. He has the right to do that. Go retry this case, assuming that he has the right to keep and bear an arms for his own defense. So he basically said, you got the rule wrong. Go and do it with the rule. And then, of course, DC went, all right, our bad. We'll go form a new rule. Then Chicago said, well, that's just federal. That has nothing to do with us as a state. And so then the argument in McDonald versus Chicago was, is this incorporated to the states?
Correct.
And they said, yes, it is. So again, was the law correctly applied?
And that's how it works. And again, it's not the right and wrong. It's not the innocence, or it's not the guilt or not guilty. It is, how is the law applied? And your appellate lawyers are, listen, they review what the judge does, they review what the prosecutor does, what the defense attorney does, and I'll tell you, they are the worst human beings on earth. They're just, I've had some of my cases appealed, and they, well, why didn't you say this? Well, why did you object here? Well, why didn't you do this here? And it's just like, have you ever tried a case?
Right.
Have you ever done? But they're doing this because, again, and the other thing that they, when all else fails, they try and get you on ineffectiveness of counsel. Because you should have objected at this point, you didn't do this, you should have made a motion to do this, or the motion wasn't done right. You still have lots of opportunities in the appellate world, but let me go back. It's rare when they overturn a verdict of a jury.
And it should be rare, I think.
Yeah.
Because we assume that the jury got it right, unless we have a real compelling reason to go, man, we really made a mistake here.
No, I've made that argument before, on a guilty charge. Judge, there's there's no way in the world a jury listening to these facts could come to this conclusion. I'm asking you to take it out of their hands. And, it's never happened, but, again, it's...
That's when you make motions for dismissal and those kinds of things. We're wasting everybody's time, whatever.
Well, it's not a waste of time, because, again, listen, I've had a first-degree murder charge dropped in a directed verdict, which is very rare and very unheard of. But, again, if I didn't make it at that point and it went forward, guess what? It would never, the appeals court isn't going to come back and say, well, if he should have made this motion, it would have been granted, so we're going to do it. I have to do it, otherwise it would have been malpractice.
Well, and I think that we assume the sanctity of the court, right? We assume, wait a minute, somebody we've elected to be a judge is going to do their best.
Yes.
The attorneys are both sides are going to do their job and do their best. So the jury is going to hear the best, and the jury is good, sane, sober, moral, prudent people who are going to do their best. So as a general rule, the number of overturns on appeal are very few. The number of cases that they hear, very few.
Correct. Because again, you're talking 3%.
Right.
And there's a difference from, you're granted a right to an appeal versus a leave to appeal. A leave basically says, well, you got to apply to us. If we want to hear it, we'll hear it. But if not, yeah. But if you're convicted, you get an automatic appeal, especially on a criminal case, because again, we want to make sure it's done right.
We want to make sure it's done right. And that's the big thing. We want to make sure it's done right. And so, yes, that means for us as good, sane, sober, moral, prudent people, that if we get convicted, we get somebody to look it over and make sure that it's right. But that also means this is part of our American system. And so that means that some criminals are going to go free. That's how it works.
Yes.
And we would rather, in a perfect world, 100 guilty men go free than one innocent man go to prison. I know that's not how it works in real world, but that's what the actual desire is.
Yes.
And that should be how it is, and I think that's the correct way. So, appeal process. Going to take a few years. I just recently did a series on Harold Fish here in Arizona. It took 3 years to get all the way through his appeal process.
That's pretty quick.
And that's fairly fast.
Yeah, that's pretty quick.
So it can take a long time and really isn't about the facts, right? So is more about was the rules followed or were the rules followed correctly? And I would even argue, it would seem to me, Terry, that that's a different specialty of law, appeals law.
Oh, it is.
Than even criminal defense law.
Oh, it's yeah. Those guys have a area of expertise that it's phenomenal. They're excellent writers. They are judges of us, per se, of what we've done and have we done a good job. And I often get things back saying, yep, you did everything you could, or you did all the right things, and there's those one or two who are going to say, why didn't you ask this question?
Why'd you do this
Why
thing
didn't you object here? And I get it, that's their job. They're very good at what they do.
It's what they're supposed to do. So next week we are going to talk about how that makes, what those appeals do in making case law, and how most people vastly misunderstand case law in self-defense. Terry,
Yes.
thanks for the time.
Thank you.